This is part 5 of property, looking at the landlord and tenant relationship. The landlord and tenant can create 4 different types of estates. They can create a tenancy for years, a periodic tenancy, a tenancy at will, and a tenancy at sufferance. Tenancies are governed by contracts called leases. The promises are generally independent of each other. This means that each must perform their promises regardless of whether or not the other party performs theirs. Looking again at types of tenancies, tenancy for years is created by agreement. This is measured by a fixed period of time. Statute of frauds applies to a tenancy over 1 year. An example of a tenancy for years is your 1-year lease or a 2-year lease on a condo or a commercial building. It must be in writing, and the lease is subject to the statute of frauds if it's over 1 year. Termination of the tenancy for years is automatic upon expiration of the term of that lease. So after your year, no notice is required to terminate. You have a right to renew, but it must be explicitly set out in the lease. And termination may also occur at certain breaches of the lease. Looking at periodic tenancy. As the term says, it's periodic, it's repetitive, and ongoing. This is a month-to-month lease. There's no predetermined termination date. It automatically renews until one party gives valid termination notice. Statute of frauds does not apply to periodic tenancy because it's not for a fixed term. Periodic tenancies are created by express agreement. You sign a month-to-month lease. May be created by implication. This is where a failure of an express agreement to mention a termination date. Now, a notice is required to terminate a periodic tenancy, and that notice must be given before the beginning of the intended last period of periodic tenancy. So if they want to terminate your lease January 1, they have to give you notice the end of November. As with the tenancy for years, periodic tenancy may also be terminated at certain breaches of the lease. Looking at tenancy at will, this is no specific term. Tenancy at will continues until terminated by a party thereto. A tenancy at will is created by either an express agreement or by implication, such as you're allowed to live with somebody for a period of time. This may create a tenancy at will. Again, so it may be created by an express agreement or by implication if a party is allowed to occupy premises. Now, where you do occupy a premises under a tenancy at will, or what may be considered a tenancy at will, if you make a payment of rent, that converts a tenancy at will into a periodic tenancy. Now, most states have statutes requiring advance notice for termination of a tenancy at will. Otherwise, it may be terminated by either party without advance notice. However, the other party must be given a reasonable time to vacate the premises. Looking at tenancy at sufferance, this is a period after expiration of the lease which the tenant remains on the premise. The tenant is bound by the prior lease terms, and the tenancy at sufferance is terminated by departure of the tenant, or the tenant is evicted, or where the tenant and the landlord agree to a renewed lease. Duties of the tenant. Generally, they must pay rent and avoid waste. In regards to paying rent, they must pay proportionate to part of the term. So if they're only residing there for a half a month, they only have to pay half a month. The tenant need not pay if the premises are destroyed. That makes sense. Tenant has a duty to avoid waste, and this is the same as those imposed on the holder of current possessory property interests. So you have to avoid ameliorative and permissive waste. The tenant in a non-residential lease does not have a duty to repair. If the duty is stated in a lease, that's voided. In a non-residential lease, like a commercial lease, that duty will apply. Looking at landlord's remedies against the tenant for the tenant's breach, the landlord may sue for unpaid rent due, but not future rent. The landlord has a duty to mitigate. This means that they have a duty to make an effort to re-rent the leasehold. They may only hold breaching tenant liable for deficiency. So if your rent is $500 and they're able to re-rent it for $450, you may be liable for that $50 deficiency. A holdover tenant is a tenant that remains after the lease expiration. They may treat as a periodic tenant or tenant in sufferance. Duties of the landlord. The landlord has a duty to give possession. Failure to do so relieves tenant of obligation to pay rent. It's understandable. The landlord has a duty to repair, and they must repair. In commercial leases, as stated above, they may place this burden on the tenant. The landlord has a duty to provide a warranty of habitability. In residential context, is an implied warranty where the landlord has a duty to maintain property such that it is reasonably suited for residential use. An example may be a failure to comply with a housing code, may be an indicator of not meeting the warranty of habitability. In this situation, the tenant may withhold rent and remedy the defect and offset rent, but must first notify the landlord of the defect and provide the landlord a reasonable opportunity to correct the defect. The landlord also has a duty to provide and or meet the covenant of quiet enjoyment. This applies in both residential and commercial leases. It's an implied warranty. May be breached where the landlord or through the landlord possession of the tenant is disrupted. It's the duty of the landlord under the covenant of quiet enjoyment to take action against tenants who are nuisances or their nuisance-like behavior and control common areas. Now, breach of the covenant of quiet enjoyment may amount to actual and or constructive eviction. It's actual eviction where the tenant has been removed from the premises. This terminates the lease. Partial eviction is where the tenant is prevented from possessing or using a portion of the premises. Here the tenant may seek relief. Where the landlord is responsible for the partial eviction, the tenant is excused from paying rent for the entire premises. Or a third party is responsible for the partial eviction, the tenant is not excused from rent. Looking at constructive eviction, again, breach of the covenant of quiet enjoyment may amount to actual and or constructive eviction. Constructive eviction is substantial interference with the tenant's use and or enjoyment of the leasehold. Here the tenant is excused from rent but must give notice and vacate. And that completes part 5 of property.